The Constitution of India, Part 5, The Union, Chapter 2. Parliament, Powers, Privileges and Immunities of Parliament and its Members. Article 110, Definition of Money Bills. Subclause 1. For the purposes of this chapter, a bill shall be deemed to be a money bill if it contains only provisions dealing with all or any of the following matters, namely, a. The imposition, abolition, remission, alteration or regulation of any tax, b. The regulation of the borrowing of money or the giving of any guarantee by the Government of India, or the amendment of the law with respect to any financial obligations undertaken or to be undertaken by the Government of India, c. The custody of the Consolidated Fund or the Contingency Fund of India, the payment of monies into or the withdrawal of monies from any such fund, d. The appropriation of monies out of the Consolidated Fund of India, e. The declaring of any expenditure to be expenditure charged on the Consolidated Fund of India or the increasing of the amount of any such expenditure, f. The receipt of money on account of the Consolidated Fund of India or the Public Account of India or the custody or issue of such money or the audit of the accounts of the Union or of a state, or, g. Any matter incidental to any of the matters specified in subclauses, a. 2, f. Subclause 2. A bill shall not be deemed to be a money bill by reason only that it provides for the imposition of fines or other pecuniary penalties, or for the demand or payment of fees for licenses or fees for services rendered, or by reason that it provides for the imposition, abolition, remission, alteration or regulation of any tax by any local authority or body for local purposes. Subclause 3. If any question arises whether a bill is a money bill or not, the decision of the Speaker of the House of the People thereon shall be final. Subclause 4. There shall be endorsed on every money bill when it is transmitted to the Council of States under Article 109, and when it is presented to the President for assent under Article 111, the certificate of the Speaker of the House of the People signed by him that it is a money bill. Article 111. Assent to bills. When a bill has been passed by the Houses of Parliament, it shall be presented to the President, and the President shall declare either that he assents to the bill, or that he withholds assent therefrom, provided that the President may, as soon as possible after the presentation to him of a bill for assent, return the bill if it is not a money bill to the Houses with a message requesting that they will reconsider the bill or any specified provisions thereof and, in particular, will consider the desirability of introducing any such amendments as he may recommend in his message, and when a bill is so returned, the Houses shall reconsider the bill accordingly, and if the bill is passed again by the Houses with or without amendment and presented to the President for assent, the President shall not withhold assent therefrom. Procedure in Financial Matters. Article 112, Annual Financial Statement. Subclause 1. The President shall in respect of every financial year cause to be laid before both the Houses of Parliament a statement of the estimated receipts and expenditure of the Government of India for that year, in this part referred to as the Annual Financial Statement. Subclause 2. The estimates of expenditure embodied in the Annual Financial Statement shall show separately, a. The sums required to meet expenditure described by this Constitution as expenditure charged upon the Consolidated Fund of India, and, b. The sums required to meet other expenditure proposed to be made from the Consolidated Fund of India, and shall distinguish expenditure on revenue account from other expenditure. Subclause 3. The following expenditure shall be expenditure charged on the Consolidated Fund of India, a. The emoluments and allowances of the President and other expenditure relating to his office, b. The salaries and allowances of the Chairman and the Deputy Chairman of the Council of States and the Speaker and the Deputy Speaker of the House of the People, c. Debt charges for which the Government of India is liable including interest, sinking fund charges and redemption charges, and other expenditure relating to the raising of loans and the service and redemption of debt, d. I. The salaries, allowances and pensions payable to or in respect of judges of the Supreme Court, 2. The pensions payable to or in respect of judges of the Federal Court, 3. the pensions payable to or in respect of judges of any high court which exercises jurisdiction in relation to any area included in the territory of India or which at any time before the commencement of this Constitution exercised jurisdiction in relation to any area included in a governor's province of the Dominion of India, the salary, allowances and pension payable to or in respect of the Comptroller and Auditor General of India, any sums required to satisfy any judgment, decree or award of any court or arbitral tribunal, any other expenditure declared by this Constitution or by Parliament by law to be so charged. Article 113, Procedure in Parliament with respect to estimates. Subclause 1. So much of the estimates as relates to expenditure charged upon the Consolidated Fund of India shall not be submitted to the vote of Parliament, but nothing in this clause shall be construed as preventing the discussion in either House of Parliament of any of those estimates. Subclause 2. So much of the said estimates as relates to other expenditure shall be submitted in the form of demands for grants to the House of the People, and the House of the People shall have power to assent, or to refuse to assent, to any demand, or to assent to any demand subject to a reduction of the amount specified therein. Subclause 3. No demand for a grant shall be made except on the recommendation of the President. Article 114, Appropriation Bills. Subclause 1. As soon as may be after the grants under Article 113 have been made by the House of the People, there shall be introduced a bill to provide for the appropriation out of the Consolidated Fund of India of all monies required to meet, a. the grants so made by the House of the People, and, b. the expenditure charged on the Consolidated Fund of India but not exceeding in any case the amount shown in the statement previously laid before Parliament. Subclause 2. No amendment shall be proposed to any such bill in either House of Parliament which will have the effect of varying the amount or altering the destination of any grant so made or varying the amount of any expenditure charged on the Consolidated Fund of India, and the decision of the person presiding as to whether an amendment is inadmissible under this clause shall be final. Subclause 3. Subject to the provisions of Articles 115 and 116. No money shall be withdrawn from the Consolidated Fund of India except under appropriation made by law passed in accordance with the provisions of this article.